This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to talk about appraisal and why the amount of a loss is by contract terms set by an appraisal award, and payment by the insurer of the appraisal award should defeat any claim of bad faith or tortious conduct on the part of an insurer. Hurricane damage to a dwelling was established by an appraisal award, and the insurer paid the award in full, only to be sued. In a case entitled Homeowners of America Insurance Company versus Emilio Menchaca, the Court of Appeals of Texas on July 31, 2025, dealt with the claim after a hurricane presented to Homeowners Insurance Company, HAIC, estimated that the cost of covered repair to Menchaca's house was $3,688.54, which was less than his deductible, and therefore no payment would be made. After Menchaca retained counsel, HAIC advised that under the terms of the policy, Menchaca was required to first invoke the appraisal process prior to filing suit, and that HAIC reserved the right to request that Menchaca and any adjuster hired on his behalf submit to an examination under oath. On August 23, 2018, Menchaca's counsel sent a demand notice letter to HAIC stating that Menchaca had sustained $48,757.98 in economic damages based on an estimate prepared by Henry Sienema, Vice President of Case Strategies Group. The letter demanded that HAIC pay the $48,757.98 in actual damages, $2,400 in attorney's fees, and $2,000 in expenses, totaling $53,157.98 to resolve the matter without litigation. HAIC's response was to invoke the appraisal process, and eventually HAIC's appraiser and the agreed umpire signed an appraisal award setting the amount of loss for Menchaca's claim. On June 4, 2021, without admitting liability, HAIC issued a check to Menchaca in the amount of $7,085.86. The actual cash value of $13,145.86 assigned by the appraisers minus the $6,060 deductible under Menchaca's policy. The case went to trial, and trial began, and the jury returned a verdict for Menchaca. The trial court rendered final judgment on the jury's verdict on May 31, 2023, ordering that Menchaca recover from HAIC $300,000 in mental anguish damages, $250,000 for his reasonable and necessary attorney's fees, and $93,000 in prejudgment interest. HAIC appealed. The key points of the case start with, first, the initial claim and appraisal. Menchaca's initial claim was denied as the estimated repair cost was less than deductible. Menchaca then demanded more, leading HAIC to invoke the appraisal process. HAIC, after the appraisal award, filed for declaratory judgment, questioning the qualifications of Menchaca's appraiser and requesting an examination under oath from Menchaca. Menchaca counterclaimed alleging violations of Texas Insurance Code, fraud, breach of contract, and bad faith. The jury found in favor of Menchaca, awarding him $300,000 plus in anguish damages and prejudgment interest. HAIC appealed. arguing it had complied with its obligations under the policy by paying the appraisal award, and the Menchaca's mental anguish damages were not recoverable as an independent injury. The Court of Appeals agreed with HAIC, reversing the trial court's judgment and ruling that Menchaca take nothing on his counterclaim. Discussing the law and facts, the Court of Appeal noted that the only actual damages Menchaca sought were lost policy benefits, which HAIC paid when it paid the appraisal award. The only actual damages Menchaca sought are the policy benefits wrongfully withheld, and those benefits had already been paid pursuant to the policy. The trial court therefore erred in rendering judgment in favor of Menchaca on his contractual and extra-contractual claims, awarding him $300,000 in mental anguish damages. Therefore, the Court of Appeal concluded that HAIC discharged its liability under the policy by paying the appraisal amount in full along with statutory interest and complied with its obligations under the policy. Because HAIC has paid the full appraisal award and any possible statutory interest, Menchaca could not recover attorney's fees, and the trial court erred in awarding him such. The Court of Appeals also sustained HAIC's claim that the trial court's May 31, 2023 final judgment was erroneous and rendered judgment that Menchaca take nothing on his counterclaim against HAIC. In my opinion, it is axiomatic that an appraisal award sets the amount of loss in accordance with the terms and conditions of the contract of insurance. The jury was either improperly instructed or ignored the law when it was established that the insurer paid the full amount of the appraisal award in full with interest, and yet they approved tort damages for Mr. Menchaca. An insurer that pays everything it owes under the terms of the policy contract cannot be held for tort and bad faith damages and attorney's fees. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. You can subscribe to the blog, and if you do, you'll receive notice of every blog posting, usually 5 or 6 a week, and you'll gain access to the more than 5,150 blog posts. You can also subscribe to these videos at rumble.com and youtube.com, and if you do, I'd appreciate it if you click on the like button at YouTube or the thumbs up button on rumble.com. And please tell your friends and colleagues about this blog and these videos so that they too can subscribe. And if you're interested in further detail about insurance, insurance claims, insurance law, and insurance fraud, please consider for a very small fee subscribing to my Substack publications. Thank you for your attention.